Welcome back to SCOTUS Oral Arguments and Opinions. Today, we'll discuss an emergency docket case that sparked fierce disagreement among the justices, and that raises fundamental questions about executive power. McMahon v. New York centers on President Trump's attempt to eliminate the Department of Education, not through Congress, but by firing the people who work there. On July 14th, the Supreme Court, by a 6-3 vote, granted emergency relief allowing the mass terminations to proceed despite two lower courts finding likely constitutional violations. Justice Sotomayor penned a scathing dissent warning that the majority was enabling executive lawlessness and threatening constitutional separation of powers. Justices Kagan and Jackson joined this dissent. Before discussing the emergency docket, let's briefly discuss the regular docket. The court made no updates on the regular docket. At present, no order lists are scheduled for release. This suggests that the justices may not take on or reject new cases at least until August, but they'll remain busy juggling cases on the emergency docket. Speaking of the emergency docket, let's discuss McMahon versus New York. Let me paint the picture. On March 11, 2025, Secretary of Education Linda McMahon implemented what the government called a reduction in force, or RIF. This wasn't your typical government downsizing. McMahon fired over 50% of the department's workforce, roughly 1,400 employees, in a single day. What made this extraordinary wasn't just the scope. McMahon publicly described the mass termination as the first step on the road to a total shutdown of the department. President Trump had repeatedly stated his goal to eliminate the Department of Education entirely, calling it a big con job and directing McMahon to put herself out of a job. Here's the constitutional problem. Only Congress can create or abolish federal agencies. The Department of Education Organization Act of 1979 established this cabinet-level agency to administer federal education programs, enforce civil rights laws in schools, and distribute billions in federal funding to states and students. 20 states, led by New York, Massachusetts, Hawaii, and California, filed suit. School districts like Somerville and East Hampton sought to prevent the RIF. Teachers' unions and educational organizations also sued. These plaintiffs argued the mass firings would cripple services their communities depend on. On the other side stood the Trump administration, President Trump, Secretary McMahon, and the Department of Education. The administration maintained this was routine government efficiency, not agency elimination. The Federal District Court in Massachusetts heard arguments on April 25, 2025. On May 22, the court granted the preliminary injunction. The judge found the plaintiffs would likely prove the administration violated both the Constitution and federal administrative law. The court ordered the department to reinstate the fired employees and restore the agency's ability to perform its statutory functions. The judge emphasized this didn't require specific staffing levels, but ensured the department could operate while litigation continued. The First Circuit Court of Appeals upheld the preliminary injunction. The appeals court noted the government does not even attempt to engage with the district court's record-based findings about the reduction in force's scope, intent, and disabling impact on the department's statutory functions. What happened next illustrates the power of the Supreme Court's emergency docket. After losing in both lower courts, the government filed an emergency application asking the Supreme Court to stay the preliminary injunction. On July 14, 2025, the Supreme Court granted the stay by an undisclosed vote. The court's brief order allowed the mass terminations to proceed while appeals continue. The stay remains in effect pending the First Circuit's decision and any subsequent petition for Supreme Court review. In support of the stay request, the government advanced three main arguments. First, the administration argued all plaintiffs lacked standing to challenge federal employment decisions. Standing requires plaintiffs to show actual injury fairly traceable to the defendant's actions that courts can remedy. The government characterized the plaintiffs' claims as speculative, downstream injuries, too remote from the personnel decisions to qualify for federal court review. The administration pointed to a recent Supreme Court case, OPM AFGE, where the court granted the government's stay application. I talked about OPM AFGE on my July 9th episode. More on this below. Second, the government argued federal district courts lacked jurisdiction over the case. The Civil Service Reform Act creates an exclusive system for reviewing federal personnel decisions through administrative agencies, not federal courts. The government contended this case belonged before the Merit Systems Protection Board, not a federal judge. Third, the administration maintained this was legitimate executive efficiency, not agency elimination. Government lawyers distinguish between the president's legislative goal of abolishing the department, which requires congressional action, and administrative measures to improve efficiency, which fall within executive authority. The states pushed back hard on every point. On standing, the states argued they suffered concrete, immediate injuries from the department's inability to perform statutory functions. States depend on federal education programs, civil rights enforcement, and funding streams that the mass firings disrupted. The states distinguished their case from OPMV AFGE, emphasizing they were direct beneficiaries of statutory programs the department could no longer adequately administer. The plaintiffs pointed to specific harms. The complete abolition of the Office of English Language Acquisition disrupted special education services and delayed civil rights investigations. On jurisdiction, the states relied on Axon Enterprise versus Federal Trade Commission, where the Supreme Court held that structural challenges to the very existence of an agency belong in federal district court, not administrative proceedings designed for individual employment disputes. Most importantly, the states argued the efficiency rationale was pretextual. Secretary McMahon's own statement that the firings represented the first step on the road to a total shutdown contradicted any legitimate efficiency purpose. The states contended the executive branch cannot circumvent Congress's constitutional authority to create and abolish agencies by simply firing everyone who works there. Justice Sotomayor filed a blistering dissent. Joined by Justices Kagan and Jackson, Sotomayor's 19-page dissent that reads more like a constitutional alarm bell than typical judicial writing. Sotomayor opened with fundamental constitutional principles. Only Congress has the power to abolish the department. The executive's task, by contrast, is to take care that the laws be faithfully executed. Sotomayor characterized the president's actions as attempting to eliminate a cabinet-level agency established by Congress nearly half a century ago through executive fiat. The dissent employed unusually sharp language for Supreme Court opinions. Sotomayor accused the majority of being either willfully blind to the implications of its ruling or naive. Sotomayor wrote that when the executive publicly announces its intent to break the law and then executes on that promise, it is the judiciary's duty to check that lawlessness, not expedite it. Sotomayor systematically dismantled the government's arguments. On standing, Sotomayor noted the government does not even attempt to rebut the lower court's finding that petitioners' actions are likely unconstitutional and unlawful under the APA. Sotomayor emphasized that states face concrete injuries from the department's inability to provide its statutorily mandated services. On the government's efficiency rationale, Sotomayor was particularly harsh, calling it plainly pretextual. Sotomayor quoted the court's warning that courts are not required to exhibit a naivete from which ordinary citizens are free. Sotomayor argued that accepting the efficiency rationale would require ignoring the record and jettisoning common sense. The dissent concluded with institutional warnings. The president must take care that the laws are faithfully executed, not set out to dismantle them. That basic rule undergirds our Constitution's separation of powers. Yet today, the majority rewards clear defiance of that core principle with emergency relief. The OPMVA FGE connection. Now, here's where this case becomes part of a bigger story. The government's McMahon arguments weren't developed in isolation. Just months earlier, the Trump administration faced similar challenges in OPMVA FGE, which involved Executive Order 14210 mandating government-wide workforce reductions. In OPMVA FGE, President Trump ordered agencies to plan large-scale reductions in force across multiple federal agencies. Unions and advocacy organizations challenged this as unlawful agency restructuring without congressional authorization. The government used nearly identical arguments: efficiency rationales, standing challenges, and Civil Service Reform Act jurisdictional bars. Lower courts in OPMVA-FGE also ruled against the government. District courts found the executive order exceeded presidential authority because Congress grants reorganization authority to presidents, but that authority expired in 1984. The Ninth Circuit upheld preliminary injunctions blocking implementation. But here's what's fascinating. When the government sought emergency relief from the Supreme Court in OPM versus AFGE, Justice Sotomayor took a completely different approach. Instead of the blistering dissent we saw in McMahon, Sotomayor wrote a brief, measured concurrence supporting the court's stay. In OPM v. AFGE, Sotomayor noted that the executive order required compliance consistent with applicable law and that the plans themselves are not before this court. Sotomayor's tone was deferential, emphasizing the district court's future role in evaluating implementation. What emerges from comparing these cases is a pattern of escalating executive assertions of power over federal agencies. OPM v. AFGE involved government-wide workforce reductions that the administration characterized as efficiency measures. McMahon represented a more direct constitutional challenge: the explicit elimination of a specific cabinet agency in service of an acknowledged political goal. The government employed nearly identical litigation strategies in both cases. Government lawyers advanced the same standing arguments, the same jurisdictional challenges, and the same efficiency rationales. This suggests coordinated legal strategy for defending mass personnel actions across multiple cases. Lower courts consistently found constitutional violations in both cases. District judges conducted careful, evidence-based analysis and found the executive actions exceeded presidential authority. Circuit courts upheld these findings, suggesting judicial recognition of constitutional limits on executive agency restructuring. But the Supreme Court's emergency docket tells a different story. In both cases, the court intervened to enable executive actions despite strong lower court findings against the government. This pattern suggests institutional deference to executive power claims in emergency postures, even when constitutional separation of powers is at stake. One striking comparison involves Justice Sotomayor's dichotomy between these cases. The transformation from measured concurrence in OPM v. AFGE to constitutional alarm in McMahon suggests either that the McMahon facts were more egregious or that Sotomayor became increasingly concerned about executive overreach patterns. Several factors distinguish McMahon from OPM v. AFGE. McMahon involved a specific agency with clear congressional mandate, making constitutional questions cleaner. Secretary McMahon's public statements explicitly connected the personnel actions to agency elimination goals, making pretextual efficiency arguments harder to maintain. Justice Jackson's dissent in OPM v. AFGE presaged many themes that appeared in Sotomayor's McMahon dissent. Jackson criticized the court's emergency docket abuse, writing that the court showed demonstrated enthusiasm for greenlighting this president's legally dubious actions in an emergency posture. Jackson emphasized institutional limitations. From its lofty perch far from the facts or the evidence, this court lacks the capacity to fully evaluate, much less responsibly override, reasoned lower court fact-finding. This critique of fact-free emergency review echoed in Sotomayor's McMahon dissent. These cases raise fundamental questions about executive power and congressional authority. The Constitution grants Congress power to create federal agencies and prescribe their functions. Presidents have sought congressional authorization for major government reorganizations throughout American history. The Administrative Procedure Act requires agencies to provide reasoned explanations for their actions. Courts can strike down agency decisions that are arbitrary, capricious, or pretextual. The separation of powers doctrine prevents any branch from usurping another's constitutional authority. What makes these cases constitutionally significant is the claim that executive personnel decisions can effectively nullify congressional statutes. If presidents can eliminate agencies by firing their employees, this potentially circumvents the legislative process for agency creation and abolition. Both cases also highlight concerns about the Supreme Court's emergency docket. Emergency relief traditionally requires showing likelihood of success on the merits, irreparable harm, and that the balance of equities favors relief. Courts historically grant such relief only under extraordinary circumstances. Critics argue the court increasingly uses emergency relief to enable controversial government actions without full briefing and argument. Defenders contend the court appropriately prevents irreparable harm while allowing full litigation to proceed. Justice Jackson's OPM v. AFGE dissent captured this tension. Emergency applications force the court to act on a short fuse without benefit of full briefing and oral argument, while casually discarding 55 pages of evidence-based lower court reasoning. Looking forward, McMahon v. New York remains active litigation. The stay allows the mass terminations to proceed while the First Circuit considers the government's appeal. If the appeals court upholds the preliminary injunction, the government will likely petition the Supreme Court for full review. The case could produce a landmark ruling on executive power over federal agencies. The court might clarify when personnel decisions cross the line into unconstitutional agency elimination. Alternatively, the court might address standing requirements for challenging federal agency restructuring. The broader pattern emerging from McMahon and OPM v. AFGE suggests ongoing constitutional tensions between executive efficiency claims and congressional authority over agency structure. These cases test whether traditional separation of powers principles apply to modern administrative governance. Conclusion: McMahon v. New York encapsulates fundamental questions about American constitutional government. Can presidents eliminate congressionally created agencies by firing their employees? Do courts have authority to stop such actions? How should the Supreme Court balance emergency relief against constitutional violations? Justice Sotomayor's dissent frames these questions starkly. The president must take care that the laws are faithfully executed, not set out to dismantle them. The majority's silence leaves these constitutional questions unresolved while executive actions proceed. Whether one agrees with the government's efficiency arguments or the state's constitutional challenges, McMahon represents a significant test of separation of powers in the modern administrative state. The case demonstrates how personnel decisions can become constitutional crises when executive and legislative authority collide. That's our deep dive into McMahon versus New York and its connection to the broader pattern of executive power cases. Next time, we'll explore how these emergency docket decisions shape constitutional law beyond the immediate cases. Thanks for listening to SCOTUS Oral Arguments and Opinions. If you enjoy, please follow, rate, and share. Talk to you soon.